Committee. This is our final evidence session on our inquiry into the draft Commonhold and Leasehold Reform Bill. My name is Florence Eshlomi and I'm the chair of the committee. Can I ask committee members to please introduce themselves?
I'm Gagam Mahindra, I'm the Conservative Member of Parliament for South West Hertfordshire.
Lee Dillon, Liberal Democrat MP for Newbury.
I'm Chris Curtis, the MP for Milton Keynes North.
Sarah Smith, Member of Parliament in Hyndburn.
Sean Woodcock, MP for Banbury.
Andrew Cooper, Member of Parliament for Mid Cheshire.
Mary Ellis, Member of Parliament for Ribble Valley.
Can I ask our guests to introduce themselves, please?
Morning everyone, I'm Caroline Crowther, one of the housing directors in M8CLG. One of my responsibilities is leasehold reform.
Matthew Pennycook, I'm the Minister of Housing and Planning.
Hi, I'm Rachel Rayner, I'm the Deputy Director for Commonhold and Leasehold Reform.
Thank you very much. Everyone will be aware that the government has asked the Housing, Communities and Local Government Select Committee to carry out and undertake pre-leg scrutiny on the draft Commonhold and Leasehold Bill before the final version is introduced to Parliament. We've had a series of meetings over the last few weeks, a range of evidence sessions, a number of written submissions coming through to the committee, and this is our opportunity to question the Minister and officials. Minister, I understand that you wanted to make a short opening statement.
Briefly, if I can, Chair, morning to you and to members of the committee. But before I begin, can I put on record my thanks for the work you've already undertaken in scrutinising the draft bill, and my appreciation to all the members of the public and stakeholders who've engaged with the PLS process. I know we've got a lot to get through, so I don't intend to make lengthy opening remarks, but I do want to make a number of important points that I hope will help inform the discussion over the next hour and a half or so. The first relates to the government's manifesto. In it, we committed to finally bring the feudal leasehold system to an end, to enacting the package of Law Commission proposals on leasehold enfranchisement, right to manage and commonhold, to take further steps to ban new leasehold flats and ensure commonhold is the default tenure, to tackle unregulated unaffordable ground rent charges, and to bring the injustice of fleecehold private housing estates and unfair maintenance costs to an end. I want you as members of the committee and everyone watching our proceedings to know that I take those commitments, which I developed in opposition, extremely seriously, and that as a government we remain firmly committed to honouring each and every one of them. As you know, the Law Commission set out a coherent and holistic reform package across 3 reports. Sadly, these blueprints were not in turn followed by 3 distinct and internally coherent pieces of legislation, as would have been logical in my view. We should have had 3 separate bills: enfranchisement, right to manage and commonhold. The draft bill brings forward some of the reforms to commonhold recommended by the Law Commission. However, the Leasehold and Freehold Reform Act 2024, as you know, haphazardly cherry-picked the Commission's recommendations on enfranchisement and took forward only a very small number of its recommendations in respect to the right to manage. As I made clear in the written ministerial statement I issued in November 2024, that choice has rendered the process of holistic and coherent leasehold and commonhold reform more challenging, and we now have to work through how best to take forward those remaining recommendations. The second point I want to make just concerns our policy. It is to do what's necessary to honour the commitments made in our manifesto over the course of this Parliament. That means continuing to bring into force as early as possible as we can in each instance those reforms to the leasehold system already in statute through the extensive programme of secondary legislation that is required. And it means legislating through this draft bill, but also through other pieces of primary legislation that will be required to put in place the wider set of reforms necessary to bring the system as we know it to an end. I make the point simply to reiterate what I've told the House on a number of previous occasions, namely that the draft bill you are scrutinising will not be the last word on leasehold reform before the next general election. And my final point, Chair, just concerns our aims. It is to bring the leasehold system to an end in this Parliament, as I've said. What do we mean by that? We obviously don't mean the outright abolition of the system overnight. That's the litmus test that purists would have you believe is the only defensible course of action. We didn't promise in our manifesto to terminate circa 5 million lease agreements overnight, with the colossal disruption, cost and complexity that would entail, not to mention the detrimental impact such a course of action would have on enfranchised and RTM buildings. By end, we mean preventing the system from perpetuating itself by making commonhold the default tenure going forward, and then reducing the prevalence of existing leasehold by making it much easier for leaseholders to enfranchise, to control the buildings they live in, and to convert to commonhold. Chair, it took 29 years from 1896 to 1925 to put the modern leasehold system in place through the Law of Property Act at a time when both the law and society, I would argue, were far less complex. I want to just emphasise the point that despite what the naysayers say, despite what the bad faith commentators assert, this government, in my view, is progressing a staggeringly ambitious overhaul of property law, probably the most ambitious in a century, if not longer. It can't be done overnight, but we'll do it before this Parliament ends, and we're determined to finish the job. Thank you.
Thank you for that, Minister. I think it just outlines the complexity of this legislation, but equally why it's really important that this Parliament and the government do get it right. There are a number of people who've been waiting for far too long, and we understand that there may be other areas where the government would need to legislate to do that. Just starting off on the issue on ground rents, Gagan.
Minister, thank you for that intro. Can you just explain to the committee and the audience what evidence underpins your decision for a 40-year transition period before change to peppercorn for existing ground rents?
Yes, so in a sense it's a very general question. We took obviously a comprehensive analysis of how we should honour the commitments in our manifesto to tackle unaffordable, unregulated ground rents. We've engaged a very wide range of stakeholders, and we think the policy that we have put in the draft bill is the most appropriate, the most justified and proportionate way to meet those ends. And that's why we alighted on both the £250 cash cap and the 40-year transition to peppercorn.
Can I probe a little bit more? Why not 35 years? Why not 45 years? Why specifically 40 years is the proposal?
It's a fair question. I think from the previous sessions I've seen where other figures, including previous secretaries of state, have given evidence, there's a range of views on this matter. I think what you understand, as I think the public understand, is the shorter the transition on the peppercorn time, the greater the disruption, potentially in terms of impacts on buildings, we can come to that, but also the greater the legal risk. And I come back to the point, and I won't be able to probably say much more than this in terms of obviously not going into the legal advice government has received, but we think that is the most deliverable and defensible intervention that meets our manifesto commitments and allows us to get it in place as quickly as possible to the benefit of leaseholders.
Okay, and could the £250 cap on ground rents come into force 2 months after Royal Assent rather in late 2028?
Might bring officials in on this one to supplement what I'm going to say, but essentially the bulk of the measure, as we intend to take it forward, is set out in the draft bill. There are a number of remaining policy choices that we do need to work through. I think we flagged a number of those to the committee. Quid pro quo leases are a good example of some of the issues that we're sort of working through that we need to give a bit more further consideration. But essentially we want to be able to switch it on as soon as possible. And I think depending on the answer to those policy questions, it remains an open choice as to whether we can do that through the primary legislation or whether secondary legislation is required. It partly depends on the complexity.
And the final question for me, freeholders and investors... Oh, sorry. Okay. Freeholders and investors were a bit reluctant to speak to us in public about their views. What have they been saying to you in private?
What have they been saying to us in private? Lots of their representations are public. I mean, we've had extensive engagement with a range of stakeholders, including investors. Caroline, do you want to add to?
Yeah, I mean, we have had, as you would expect, a policy of this nature to have been speaking to everyone that is potentially affected, so investors, freeholders, etc. As Matthew Pennycook says, some of that is available in public, but actually what they have also shared is quite a lot of things in confidential basis, commercially sensitive, but just to reassure the committee that we absolutely have taken on board their concerns and their issues, and that has been evident in the design of the policy and the kind of proportional aspect of it in terms of the transition to 40 years.
Andrew, so.
Thank you. Minister, I'd just like to push you a little bit further on the 40 years issue. You described how there's a range of views on this. You'll have heard Lord Gove's evidence when he spoke to the committee that he was convinced that 20 years struck the right balance, and that he convinced the then Prime Minister Rishi Sunak, that 20 years was the right balance. They presumably would have had access to the same legal advice that you will have had and that the Secretary of State will have had.
I'm not sure that is the case.
Well, perhaps you can tell us that.
But it's just a matter of common practice that I'm not privy to the advice received by previous government ministers.
Well, what my question was going to be is what you think has changed. What new evidence has emerged?
I don't know whether anything's changed because I don't know what evidence. I don't know what advice was put to Baron Gove and the previous government. I've taken advice that I received from officials, including legal opinion, and we've alighted on the policy intervention we have. But I think I was supposed to expand on the point. I mean, as I've said, there is the shorter the transition, the greater value transfer from freeholders to leaseholders.
Yeah.
I would argue that the most impactful part of the ground rent provisions in the bill is the £250 cash cap. And if you play forward what that means over time, because it's fixed in cash terms, obviously leaseholders will benefit more as time passes. So in 20 years, the cap could be worth around 60% of its value today. That is the impact, and its erosion over time through inflation is where the extra benefit will come through. Then we faced a choice on the transition to peppercorn, which is partly, I should say and emphasise, partly so that in however many years' time we eventually alight on, but if it's 40 as proposed, there won't be, numerous ground rent terms in leases of quite small values that frustrate the operation of a modern, effective property market. But in terms of the period of time, the value transfer is obviously more. That value transfer, and whether you bring the date forward from the 40 years we proposed, we think would increase the disruption implied by the policy, and it would increase the legal risk. And so again, I come back to the point that we judge this as the most justified and proportionate intervention to deal with these specific harms, and the most deliverable and defensible that allow us to get it in place for leaseholders as quickly as possible.
Again.
Thank you. Minister, you've spoken about the £250. I think some of the evidence sessions we've had previously have potentially suggested a percentage, like 0.1%. What was your rationale for going for a £250 set figure rather than a percentage of the value? Obviously, I'm mindful that some flats in London might be multi-million pounds worth of value, so £250 may seem out of kilter. Conversely, some of the regional towns, £250 might be significantly high barrier to hit.
A couple of points I'd make on that, and I do want Rachel and Caroline to have a chance to speak as well. We can share some of the questions around. I'd make probably 3 points in response to that. Firstly, there's a very clear rationale for why we picked £250 as the cash cap amount. That has historic reasons in the sense that was, although we've changed some of the law in this area, having taken forward our Renters' Rights Act, but under the 1988 Housing Act, that is the point at which you tipped over into becoming an assured short-hold tenancy, and there are ongoing issues in terms of access to mortgages and other harms that come through ground rent terms over 250. So that's the rationale for the 250 cap, and it was obviously in the 2023 consultation. Second point I'd make is leaseholders who have ground rent terms over £250 are not just small numbers, and it's not just a London issue. There are leaseholders across the country with ground rent terms higher than 250 already, or escalating on its way to being passed. That is why we know that between 770,000 and 900,000 leaseholders will benefit from the ground rent provisions in the draft bill from day one. On the specific point you asked about why 250 and a cash cap rather than 0.1, a number of reasons, but in essence, it provides certainty and clarity to all leaseholders across the country as to what they can expect. If you have a ground rent term over 250, it will come down. If you have a ground rent term under 250 and it's got an escalating provision in the clause, you'll know you'll never go above 250. If you've got a ground rent that's under 250 and no escalating clause, it won't rise. We're not pulling everyone up to 250. There is certainty and clarity about how it works. It will limit the potential for abuse. At the point you've got a 0.1 property valuation approach, everyone has to go through that process of having their property valued. I think there is the potential for abuse in the sense that leaseholders aren't clear what the process entails, what amount should come out of that. And then there is just the complexities of what a property value approach would mean in terms of every property having to be valued and all the cost and complexity that process would entail, which isn't there with the 250 cash cap. And this speaks in a sense to the sort of difference between the Leasehold and Freehold Reform Act 2024's enfranchisement provisions, where the process of calculating the premium there is based on 0.1% of property value. But that requires a property valuation to take forward the enfranchisement. The cash cap works for everyone in the country and is based on a proxy valuation that is a different methodology. That's, again, where the alignment, or misalignment in this case, between what we're proposing for everyone in terms of ground rents and those who are taking forward an enfranchisement process.
Thank you. Minister, obviously you've outlined the 250 cap and how that would benefit quite a number of people. And with this legislation, draft legislation and previous, a lot of consultation, we hear that from leaseholders up and down the country. What specific consultation would be needed after royal assent to enable the £250 cap to come into effect much quicker?
Bring officials in. I don't think any further consultation is required, Chair.
So it can come in within 2 months, as my colleague
No,
mentioned.
perhaps I didn't explain myself clearly enough. There are a number of outstanding policy questions that we need to answer in terms of how we design the particular intervention. I mentioned quid pro quo leases as a good example, which I think we flagged with the committee. What do we do with those? The more complex the intervention comes, I suppose, the more likely that we will need detailed secondary legislation to do it. If it is a fairly straightforward matter, there is a chance that we could do it through primary legislation, through just the bill. Obviously, my intention and my overriding aim as the Minister is to get those provisions in place as quickly as possible.
I think that's right. And obviously we have published the response to the 2023 consultation, which set out a range of options, and we've set out, particularly in the IA, how we've taken those into account in the development of the policy that is set out in the bill. So, as the Minister says, I think the sort of subsidiary set of issues will be working through the complexities of quid pro quo leases in particular, finalising the drafting and then bringing it into force.
And in that consultation, was there any substantive evidence in terms of the risk to pension funds or the financial markets? That's another area that's been quite a bone of contention for many people. That was some of the evidence that we heard from the freeholders. Is there substantive evidence to show that there will be a risk? Even if it's that you've received legal advice which you can't share, have you seen evidence of that?
There's a number of points I think is worth, and do jump in either. There's obviously no immediate impact on freeholders' income as a result of these reforms. So where freeholders have taken on very high debts, they'll have time to renegotiate with their creditors to find an appropriate way forward. Obviously, we expect all parties to act in line with their fiduciary duties and their responsibilities. In terms of the sort of general impact on pension fund assets, I think that was one of your points. I think it's worth seeing in context. UK pension fund assets have been estimated to amount in total to over £3 trillion. We are estimating, and we've provided you with the impact assessment, that the ground rent reforms will see a value transfer of between 10 and 12 billion pounds to leaseholders. That's obviously a very small proportion of the total. So I think this goes to the general point. Intervening retrospectively in contractual terms is not something we do lightly. There's a very high bar for it. But as I think I said when I previously gave evidence to the committee on with Minister Rigby, we think there is a very specific harm that needs to be rectified here, and that this is a justified and proportionate approach to that end. This speaks to the point, I think, that there is differences of opinion, but there's quite significant cross-party consensus behind intervening on ground rents. It was in, I think, every party's manifesto, bar some of the smaller parties. So the intervention has been socialised for some time. I would argue that third-party investors know that this was coming.
Sarah, did you want to come in very quickly, please?
Please, yes. So just again on this question of the kind of 40 versus potentially a figure like 20 years to make this transition to peppercorn. I know you can talk about the fact that based on inflation, it will have a lower impact on those that are paying this out every year. But it's the principle that it would be equivalent to about £5,000 for constituents of mine, for leaseholders themselves, in terms of what they would be paying out or they wouldn't be, depending on where we draw the line. And as I understand it, the legal advice will have weighed up the competing interests between leaseholders and freeholders. I just wonder whether it's potentially true that in that legal advice, the greater risk and consideration was given to whether freeholders would bring the case because they've got the finances, they're organised, they've already challenged the existing legislation, and not equal consideration was actually given to the normal man and woman fighting for these changes to come through, and it is Parliament and government's role to provide the voice for those people, because this is about whose side are we on. This is about taking on vested interest and companies like Grosvenor to say that we stand with people fighting for the right to not have to pay out these leases every year for absolutely zero in return.
I'm not going to be drawn on the legal advice the government was received. I'd argue, in political terms, we are taking on those vested interests. Freeholders want to see no intervention on ground rents in terms of retrospective action. We are taking on those vested interests, but in considering what the appropriate transition point is for peppercorn, and as I've clearly argued, I don't think that is the most impactful part of the ground rent provisions. I think the £250 cash cap is the most impactful element of it by far. But in considering what's appropriate, what's proportionate, what's justified, we do have to balance our ambition to protect leaseholders, not necessarily with the interests of freeholders, although that's a consideration, but also what the wider impacts were. A much shorter transition period would increase certainty and market disruption, and would, I'd argue, carry the risk of, in particular, freeholder insolvencies, which we do not want to see. So I don't think it's quite as simple, Ms Smith, in terms of whose side are we taking. We've got to consider in the round what's the impact on the system, what's the market impact. And if we get that impact wrong and overstep, freeholders will potentially suffer. If there are mass freeholder insolvencies in buildings, leaseholders will suffer. So we're trying to get the balance right in dealing with this specific harm. What's the most appropriate, justified, deliverable and defensible intervention we can make? But we're on the leaseholders' side here in the sense that the freehold industry does not want us to take any action on ground rents.
Yeah. Thank you. Andrew.
Thank you. I'd like to move on to the Law Commission's recommendations. As you'll be aware, Minister, the Law Commission produced a series of reports between 2020 and 2021 around enfranchisement, right to manage common hold, and the price payable on enfranchisement. Why did the government choose not to include the remaining Law Commission recommendations on enfranchisement and the right to manage in this draft bill?
Well, put very simply, because the bill is already very large, includes significant structural changes to the housing market on common hold, on forfeiture, on ground rents, and we can't deliver the whole of the government's common hold and leasehold reform agenda in a single piece of legislation. And as I made clear in my opening statement, there's going to have to be other legislation that brings forward other elements of the reforms we're committed to in our manifesto.
Fair enough. We have heard, though, from many leaseholders about the impact that development value in particular is having on enfranchisement premiums, which they think might be a barrier to converting to common hold for many blocks. Do you think that that is something that could specifically be carved out and addressed in the final bill?
I'm not going to be drawn on whether it will be dealt with in the draft bill. We absolutely recognise the issue here. I think it's probably worth me setting out some of the background and thinking. Obviously, we're already taking steps to make enfranchisement cheaper and easier by implementing the reforms in the 2024 Act. I'm sure we'll come to that as a separate issue. We obviously understand that in some cases development value can make the cost of buying a freehold prohibitively high. It's really worth having a look at what the Law Commission said on this point. In its valuation report, it proposed a sub-option to enable leaseholders to voluntarily agree to a restriction on future development of their property to avoid paying development value as part of the collective enfranchisement claim. But as the Law Commission noted in their own report, there's some quite challenging practical and legal difficulties to implementing this. So we are giving it consideration, we are keeping it under review, and we'll obviously listen carefully to what the committee responds to, but I recognise the challenge. I think there are a number of ways that the problem might be approached.
Turning to the right to manage, I think you've already said that you want to produce separate primary legislation on the right to manage for common hold, leasehold and freehold homes on private estates. Is that work that's already underway now? Are the Law Commission working on a draft bill for you at the moment on that?
We bring officials in on the Law Commission. I should declare an interest, by the way, Chair, that my wife is Joint Chief Executive of the Law Commission. Sorry.
We have asked the Law Commission to look at this issue, so they're not working on a draft bill, but they are working on recommendations on how we would tackle this issue. So we're not at draft bill stage yet on it.
Okay, and is the timescales for that, does that align with the timescales for this Parliament? Is it likely that those recommendations will be delivered in time for you to get an act passed before the end of this Parliament?
We intend to honour our manifesto commitments in this Parliament, as I made clear. Yeah.
Okay. I would just add that the project that the Law Commission has included in its 14th programme is looking at sort of right to manage in the context of privately managed estates as well, which the Department's supporting, and that supplements the existing work of the Law Commission, and we'll be taking that into account as well.
Is that separate? So is that going to be delivered in this Parliament as well?
Yeah, that's a separate programme of work to the existing Law Commission report on right to manage. That, as I say, that's looking at the issues in the context of privately managed estates, fleecehold estates. But obviously the two are, to an extent, complementary when we're thinking about right to manage sort of more broadly.
Okay.
Thank you. Just for clarity, Minister, you did say that in the manifesto, the wording was enact the package of Law Commission recommendations on enfranchisement, leasehold, right to manage and common holding.
Yeah.
And the ambition is still to have that within the end of this Parliament.
Let me give you a bit more clarity on that point, because I think it's useful. It is quite difficult to determine the number of outstanding recommendations from the Law Commission because the 2024 Act departed from their recommendations for holistic reform of the leasehold and RTM regimes. So some of the recommendations are now obsolete because of the way they took forward the 2024 Act. I mean, just for clarity, tell me if the committee knows this. The Law Commission recommended repealing and replacing entirely the 1967 Act relating to houses and the 1993 Act relating to flats. In the 2024 Act, the government did not follow that approach. It cherry-picked the best elements of the enfranchisement report, took forward only 4 provisions from the RTM report. So we've got to work through what finishing those remaining recommendations means. It has become more challenging in that respect. RTM is easier, in a sense, because in the 24 Act, the then government only took 4, I think it was 4.
We're going to come on to that.
We'll come on to that, but they took a small number. So both the elements relating to the nature of the right to manage and the process issues in that report are far easier to deal with. Enfranchisement is far more complex.
Thank you. Lee.
Yeah, thank you. I want to talk about managing agents. We've spoken quite a bit, Minister, privately and in the House about it. Taking your opening statement, I accept that it wasn't in the Labour manifesto, specifically about regulating managing agents, and that you've gone out for a consultation as well in terms of enacting the previous Act around management agents and looking going forward. So I think the first question is, why not this Act? Put managing agents regulation in it, if we could cover that one off first.
Yep. So, as set out, I think in my November 2024 written ministerial statement, but in other places, we've made clear we're committed to strengthening the regulation of managing agents. That's not an issue. They are going to play a key role going forward in the maintenance of multi-occupancy buildings and freehold estates. Their importance only increases in a common hold world, in a world where common holders become the default tenure, and existing leaseholders are empowered to exercise the right to manage, collectively enfranchise or convert. So their importance is there. We've got to ensure that they are appropriately regulated. I think there are in my mind, and I will bring officials in to supplement what we've done, both through the existing consultation, but also the consultations on home buying and selling, which deal with property agents in a different way. There are broadly two ways that we can approach this. One, we can layer individual interventions into this legislation and take them forward in a variety of ways. We've obviously already consulted on mandatory professional qualifications, switch and veto. These are some of the recommendations from Lord Best's report. We could take that approach of layering on regulation as we go, or we could not do any of that and step back and look to take forward Lord Best's recommendations in a more holistic way through, say, a standalone piece of primary legislation. Now, I speak regularly to Lord Best about these issues. His preference is very much the latter, and for an independent regulator to oversee the system. But there are a number of ways you can come at it. And again, I come back to, I suppose, the question Mr. Cooper asked. This bill can't do everything. It is already very large. And so we've got to look, and as a government we are looking at, we've got these set of manifesto commitments, which, as I said, I take really very seriously. We want to deliver them all in the Parliament. What is the most efficient and effective way of doing that in the coming years before we next get to the general election? But there are some choices for the government on managing agents.
And so the consultation that you did do, that ended on the 26th of September. Yep. So that's 6 months in a couple of days' time. When will we see the responses of that consultation? And were the preliminary findings of that consultation, did that help you to shape this draft common hold and leasehold bill?
I feel like I'm dominating the conversation, so I'm going to bring my officials in and then I will supplement them, but I can tell you how we break down the SI. Yeah.
I mean, there are obviously two parts to that consultation. The first half is on LUFRA implementation and particularly focuses on measures to make service charges more transparent. We have been analysing the responses to that consultation as part of developing the SI package that will implement it. We got quite a lot of responses, and I think it's fair to say, particularly on service charge accounting measures, quite a lot of feedback on how actually that is going to work in practice, which we've had to work through. The package that will deliver that is a relatively sort of complex SI package. It's 6 separate SIs, 2 on service charges, 2 on buildings insurance, 2 on litigation costs. So obviously we'll be responding to the consultation to show exactly how we're going to implement it sort of as soon as possible. And then the process will be taking forward that implementing package, again, as quickly as possible. It's just that, as I say, sort of the consultation sort of unearthed some relatively sort of technically complex issues. The second half of the consultation obviously was on sort of measures that are separate to LUFRA. It's on exactly those ROPA measures the Minister's mentioned, and additional measures in relation to asset management, in relation to Section 20 reform, and a number of other cases. Again, we are in the process of analysing those responses. It has been really helpful. It has informed the thinking on minimum qualifications in particular. And similarly, hopefully we'll be responding as soon as possible on the full set of measures in that consultation.
Lovely. I just want to put it on rep. So thank you for that response. I think there is the train of thought of Lord Best, and I agree with that in terms of the regulator. Minister, I respect your position of that professional qualification approach before you went out to consult, to give a direction of travel. But I think it'll be welcoming for the public here at home that SIs will be coming through as quickly as you can before further legislation comes through as well. So thank you for that.
Yeah, and I have made very clear that I want them to come forward as quickly as we possibly can. But I think to supplement what Rachel said, we have discovered, not least through the consultation, that what is seemingly a fairly simple intervention, let's standardise service charges and make them more transparent, is actually incredibly complex. And as we switch the whole system over to across the country, put in place a single approach, we've got to work through and ensure that we get that right. Again, the risk of getting it wrong and creating a system that isn't properly thought through.
Thank you. We've got quite a number of questions, colleagues, so shorter questions. Chris?
Just on the trade-off between sort of, well, you describe it as sort of peppering Best or doing a full Best piece of legislation. The argument for doing the former would be the length of time, or possibly even the ability to get parliamentary time to do the latter. So how confident are you, or do you have a sort of in your mind how long we might be waiting in order to get a full piece of legislation if we don't do the bits? If we regardless of whether we do bits in this piece of legislation.
I don't have a clear timeline that I can share with you, not least because I can't preempt this King's speech, let alone future King's speeches.
It'd be unlikely to be in this King's speech.
But there's not a chance on earth I can confirm what's in the King's speech to this committee today. I'm sorry.
Well, it's written already.
But on the principle you raise, I think that is one of the considerations in terms of the sort of timeline for impact. There's a world in which we could get a number of discrete managing agent provisions, say, into this draft bill, and that would be switched on at the point that that's, we receive royal assent and any secondary legislation required. If we take a standalone bill, I would say as a sort of general point of principle, that is likely to take longer, obviously, than getting specific provisions into this bill. Yeah. But it may be the right way to do it, to treat it as a single package. That's certainly what Lord Best and Mr Beales, who's got a private member's bill on this issue, would like us to do. As you'll see, if you've had a look at that private member's bill, that is not a small piece of legislation on its own. So ROPA as a whole. And one of the challenges with ROPA is that it cuts across different issues. Property agents in the round includes managing agents, it includes estate agents, property agents. So again, there's a choice here for government to make. And it's one of these where, not that I'm not on every particular issue, but very interested to hear your views about what colleagues across Parliament think is the most.
Yeah, the difficulty with that, though, is we're having to make that decision without knowing information on the trade-off. The trade-off being the timing and the ability to get a future piece of legislation.
Well, a future piece of legislation would be slower than this piece of legislation, obviously, which is before us.
Sure, but without knowing how much slower that second piece of legislation would be, it's very difficult for us to make a judgment on.
I'll weigh that up and make a judgment, but it would be good to have your general steer.
That's good. Obviously, Minister, we are very happy and commend the government on the successful defending the relevant measures in the High Court in July following the legal challenge to LAFRA. And in one of the written correspondence to us, Minister, you outlined that you will come back on the consultation, but yeah, we still haven't had that, the consultation on valuation rates on enfranchisement premiums.
Yeah. So that will be forthcoming in the coming months. No, but I think the important point here is we will go out to consult on the capitalisation and deferment rates, which, as you know, under the 24 Act, the Secretary of State sets. I just want to make the point which I have tried to stress on previous occasions. We could have consulted on those rates in September 2024, and we still would not be able to switch on the enfranchisement provisions in the 24 Act because it has this small set of specific and serious flaws that we need to fix through primary legislation.
Do you think you'll be in a position to have the corrections in the final bill then, or...?
It is my preference, it is my intention to include those fixes subject to receiving collective agreement and getting that through the process of the King's speech, but to include those in this bill. But the point I'm trying to make is the valuation rates consultation is not the constraint to switching on those provisions. It is the flaws in the bill. The flaws that I should say Baron Gove and other ministers were aware of when they let the bill go through wash-up in the last Parliament, and we were not aware of until we entered office. But we do have to fix them. That is the hard constraint to switching those on. So we'll do the valuation consultation, obviously in good time to be able to switch those on. There was an interaction with the High Court case that needed thinking through. We obviously robustly defended that case, and it was comprehensively dismissed. But I just make that point. I've seen people argue time and again that we're dragging our feet because we're not doing the valuation rates consultation, and that's why we haven't switched on. That is not the constraint here.
Okay. We'll come back to that hopefully as we progress. One of the other things obviously is there could be likelihood in terms of discussing some of the areas in this and looking at the interest of the freeholders. There's a strong likelihood that this draft legislation could be subject to another judicial review once passed. Just wanted to know some of the thinking from you and officials in terms of any contingency plans, because what we don't want is a long process where, in essence, this legislation is delayed. Coming back to what we outlined in terms of the long wait for many leaseholders.
What's the question? What's our?
Is the department looking at any contingency plans?
Our contingency plan would be to robustly contest the legal action. It's about as simple as that. as we robustly contested the case to the challenge to the 24 Act provisions. But it doesn't really go beyond that, responding to the nature of the challenge, the specific legal challenge that may or may not come. I fully expect one to come, let's be clear. This is a particularly litigious area. We will be ready for it, and we will robustly challenge it as we did the 24 Act. And I go back to, we want to see these reforms in place as quickly as possible. That is why, though, returning to the particular choices we made on ground rents, while it is to the lasting benefit of leaseholders to ensure that all of the reforms that we are alighting on through the final substantive bill are deliverable and defensible and allow us to get it in place as quickly as possible.
If the claimants get the permission to appeal, this could drag on for many years, and it could go to the Court of Appeal, Supreme Court. Again, in terms of what would happen in the interim to the many leaseholders who've been waiting, and in a sense, they'll get caught up and equally as frustrated as the government in this.
What are you asking me?
And the government's ready to deal with that full force.
We would obviously robustly defend an appeal case as well, yeah.
That's fine. Common Hold Associations, Mayor.
So I've got some questions about common hold associations, because I think one of the interesting things that's come through in some of the evidence is sort of concerns and questions about how we're going to essentially support people as they move to, a new way of working where they have to work with their neighbours in a way that they maybe haven't had to before. So I guess an initial question is, what guidance will the government publish to ensure unit owners have access to complete information to make fair, informed decisions in common hold associations?
Let me give you a top line, and then Caroline and Rachel can come in. We expect to issue guidance on a whole suite of issues relating to common hold. The industry are already preparing their own guidance. We obviously want to work closely with them to ensure that that's properly integrated with our efforts, but there will be all the appropriate guidance in place to ensure that the provisions of the bill operate effectively. Rachel?
Yeah. I mean, it's worth obviously saying that this is the bill for the common hold, but actually this is a whole cultural change. We're setting up a kind of new tenure, we're kind of reinvigorating it. And so our work with the whole sector is hugely important to us. We've already worked with the sector extensively in terms of the development of the proposals in the bill, but actually we'll be turning our eye to implementation, so working with developers, conveyancers, etc. So that is very much part of our plan in terms of having a good and robust implementation plan, and we'll work with the sector to do that. Government can't do it all themselves, but we will work with all the parties that have an interest in this.
Where do you think the key education is going to have to sit? Is that in that conversation when someone's engaging with a solicitor and the conveyancer through that process? Do you think, is it something that actually has to be earlier? And is it in schools? Is it in public education?
I mean, I'm always an advocate for starting in schools, but I mean, I do think it's right through the system. So you would start with developers and also conveyancers. I mean, I think the conveyancers and the land registry are kind of critical here. So, but the whole sector, I would argue.
And just a couple of sort of more sort of specific ones. One thing that was raised was around, is there a risk that common hold associations risk falling foul of time limits on technical breaches of company law? And should tribunal have the power to waive those breaches that do not affect the result of decisions in common hold associations? So I think the broad principle was raised in one of the previous sessions around some of those technicalities where actually, again, where everyday people are coming into a situation where they're essentially subject to company law, and how we're going to help them navigate that.
I mean, I would just add here that, I mean, having sort of resident-led management in the form of a company isn't unique to common hold. It's also the case for resident management companies and right to manage companies who are registered under Companies House. So, I mean, yes, we can pick up on the exact technicalities, but in terms of the broad principle, the nature of a common hold association was something that the Law Commission considered, which we considered in the course of making the legislation, and concluded that this was the right model.
So essentially it's already happening to some extent, and it's just that we're broadening it. And I guess then the question remains, if we're broadening it, is there a need for broader education around that?
So we would also use our lease advisory service as well. So they will have quite a key role to play in terms of educating leaseholders and potential common holders about the shift, so they would also have a key critical role there.
One point I would just add is that common hold by its nature is also more prescriptive. I mean, it is designed specifically for collective management of buildings. You've got the common hold community statement, which sets out all the core provisions. There'll be obviously local rules for individual blocks. There'll be a host of guidance specifically designed to support people. You know, the provisions set out in the bill, sort of by their nature, are designed to support people, and obviously we need to layer the guidance on top of that. But the structure in and of itself is designed to be easier to navigate.
And I think this is, to Rachel's point, this is one of those areas where we looked closely at what the Law Commission said. They explored whether common hold associations could exist as another form of corporate structure, or a bespoke corporate body, and they ultimately decided that the appropriate balance lay with retaining it as a company limited by guarantee, which, as I said, is not an unusual form of arrangement.
Okay, and just the last one for me, I guess, just sort of a specific example has come up, but that has created a wider concern, is around the sort of the quorum and the fact that, you know, you could vote with a 20% quorum. So I think the example that's come from Battersea Dogs and Cats Home has said that, you know, you could have a 20% quorum, so a small group of, you know, residents actually in attendance. If they vote, 75% of those vote in support of a ban, for example, on pets in that building. How are you expecting, you know, how are you expecting the guidance to help residents navigate a situation like that?
I think, exactly. I think this is partly why minority protections are built into the redesigned framework, so that where decisions are made by a common hold association that have a significant impact on one of the members, they have the ability to go to the tribunal to take a view on some of that.
Minister, would you expect the tribunal to give consideration to other legislation you've done in the Renters' Rights Act, for example, for people to have the right to have pets? Because in one tenure group you say you absolutely have that right, and in the other one, potentially the residents could vote not to have those pets, and then it's up to a tribunal to make that decision.
I think we haven't set out what... I mean, we wouldn't guide the tribunal to look at specific factors. The tribunal has the expertise to make those decisions and a range of powers. But I take the point about the pets, which
like
I've heard strong views on from various people.
Sarah.
So the government's obviously made a clear commitment to common hold becoming the default tenure for flat ownership. But why doesn't the bill make common hold the default outcome of a collective enfranchisement? And should leaseholders have to explicitly vote for the conversion?
Well, I think there is obviously a sort of a threshold vote for deciding to convert, which we set at 50% in the bill. Obviously, that's a reduction from 100% in the old common hold framework. So the bill is designed to make conversion easier to access. In terms of mandatory conversion, I mean, I think our position is that we want to give consumers the choice at this stage of reform, whether to convert to share a freehold in the first instance, and then whether to take that step to conversion to common hold. Although I think we anticipate that obviously as the model beds in, common hold will become more attractive to people who are in the position where they want to take control of their own building.
I think that's the point, is that we want to give, in a sense, people the maximal range of options here. We think there are advantages and benefits which common hold offers over share of freehold. But it's really up to people in the buildings themselves as to what option they want to take forward. But I would hope over time, and this goes to a point I made in my opening statement about what do we mean by ending the system. I would hope over time that the process for conversion is sufficiently easy and common hold as an alternative form of home ownership is sufficiently attractive that we do see a significant proportion of existing buildings convert over.
And has consideration been given to how non-participating leaseholders might contribute to the cost of collective enfranchisement if they choose to join the common hold at a later date? And how can you say that?
Yeah, I mean, it's one of the more complex aspects of the bill, the conversion process. And the bill, you know, includes a power where we can set a price payable for buying into the common hold at a later date. That's something that doesn't currently exist on the enfranchisement side. Obviously, we're going to have to, and I know it's come up in a number of evidence sessions that the committee's heard, but that is going to require some really careful consideration as to what that looks like and how it works. But the bill provides for that option to be available.
And should freeholders be required to disclose information about building safety status as part of the enfranchisement process so that the leaseholders are fully aware of the liabilities that they may be assuming?
I mean, what would do? Our advice in all of these instances would be to obtain legal advice, not least from the government-supported Leasehold Advisory Service as to particular circumstances. But you're talking about disclosure just as a requirement to enfranchisement.
On building safety, because obviously it's caused such a continues to be such a huge issue.
Through the common whole. Are we talking about this bill, or are we talking as a general point?
So, well, whether it would, I don't know exactly whether it would fall within this bill or would be part of the future legislation that you bring through. But arguably, while you're outlining that process for conversion, providing that protection, if you like, for those that might be considering conversion, specifically on building safety when it remains such a huge concern and challenge within the...
I mean, our hope would be that freeholders do disclose the remaining building safety liabilities. As the Minister said, we would always encourage leaseholders to take legal advice on it, just so they can understand the remaining liabilities as they move into common hold.
It would be dependent on them getting that legal advice.
Yeah.
Thank you, Chris.
I'm just going to come back to some questions on Fleecehold, if that's all right. I know you sort of mentioned some of these points in the previous responses. At the time of the King's Speech, policy papers said that the draft bill would bring the injustice of Fleecehold private estates and unfair costs to an end. It's fair to say this piece of legislation probably doesn't do that, and I think you've laid out reasonable reasons why it's going to be covered elsewhere. What commitment, approaching the question I asked previously from a slightly different angle, what commitment would you now like to make to Fleecehold, people in my constituency who are in these Fleecehold properties, in terms of when the government and how the government will address their concerns?
We do want to address their concerns and the injustices that many of them face. We've looked at, in the development of this draft bill, what specific provisions we can bring forward, and obviously have brought some forward, so the bill is not silent on private estates, on freehold estates. Rent charges provisions are in there. But we're taking forward, as you know, publication of 2 consultations late last year, both on switching on those consumer protection provisions that are in the 2024 Act, and the more thorny issue, if you like, of how we reduce the prevalence of these estates over time. I see the sort of approach of the government to freehold as a sort of 3-legged stool. You've got those immediate consumer protections that we can switch on fairly quickly, although again we're establishing a new regulatory framework, so it's not an overnight thing. Then there's this sort of very important issue of control, which the Law Commission's work is exploring. There were debates in the last Parliament about whether you could just copy and paste a right to manage over for freehold estates. It's not quite as simple as that. So again, we've asked the Law Commission to look at what's the best answer, and then getting at the prevalence issue over time, which is more challenging, and there are trade-offs that that consultation engages with. But again, it will be something that we will deal with in this Parliament as part of those wider manifesto commitments.
Are you reasonably confident that further changes, that there is going to be more primary legislation that is required to make the changes that are necessary in order to make that commitment to bring the injustice of Fleecehold private estates and unfair costs to an end?
I don't think I can sit here and make that commitment now. I think partly we need to see, particularly on the prevalence issue, what comes out of the consultation.
Okay. In terms of timings, are you broadly thinking you're going to wait for the next round of Law Commission work to come back, then make a decision on what further legislation is required, then put that legislation forward?
I think this is all, Mr. Curtis, if you sort of excuse me, extremely hypothetical. We've got 2 consultations that we got a significant amount of feedback to. Then we've got the Law Commission work on whether there is and what it would be an appropriate form of enhanced residential freeholder control of freehold estates. I think we've got to see what comes out of that before I can say to you, yes, it definitely needs legislation or it doesn't.
I think there's some concern among some people we speak to about whether moving forward with that process that you set out, that I set out and you maybe agreed with, of waiting for the Law Commission to come back and then moving forward with possible legislation off the back of that would then push us into the next Parliament. So I suppose what I'm trying to get at is whether you think there is a risk of that happening, and whether you think therefore we should be considering what we can do in this, given it's unlikely we're going to get to that. There is an argument it's unlikely we're going to get to that otherwise in Parliament.
Bring officials in it. I don't think I can answer that sitting here today. I don't know what the Law Commission are going to say that is their recommended approach on this point. It, I suppose, comes back to what you mean by the end of the injustice of Fleecehold. I would say that at the point we have switched on new consumer protections, that we're taking action, because we will take action to reduce the prevalence of private estates, and it will happen in this Parliament. But let's see what comes out of that. We will have honoured our manifesto commitment in that respect. But it depends what you think the solution is. I mean, you can tell me and I can tell you my view on it.
Well, I think, at the very least, setting up a regulator for managing agents is something I think we all broadly agree on. I don't think there's really any argument that should be done at some point. And if that requires primary legislation, and that primary legislation isn't going to come until the Law Commission has come back, and there's a chance that goes into the next Parliament, then
really
there is an
conflating
argument.
a number of quite distinct issues. We've got managing agent reform, which the Lord Best 2019 report has dealt with. We've got a Law Commission piece of work on right to manage, or what the variant of right to manage might.
A big part of the problems the injustice of what's happening on leasehold estates is because of the behaviour of managing agents acting in an unregulated way.
I agree, and I'd refer you to my previous answers on managing agents, where we're very clear we're going to deal with that.
If this committee decides that there is a chance that new primary legislation wouldn't come forward in this Parliament, do you think it is reasonable to argue for that regulation of managing agents to be included in this legislation to help those on private leasehold estates?
We will strengthen the regulation of managing agents in this Parliament. If that requires primary legislation or inclusion in this bill, that's what we'll do.
Okay. Thank you for the clarity on that, Minister. One of the issues that often comes up is obviously shared owners, and a number of them have raised concerns. So, as you know, as it currently stands, the requirement shared ownership is not compatible with the current legal framework on common hold. And shared owners have expressed to us their concerns around whether or not they would have a vote in a common hold association during that 10-year initial repair period. What specific purposes of secondary legislation will shared owners have to exercise that right to vote?
Secondary legislation in what respect?
When registered providers are not there, how would that be exercised?
Without reading out to you what's in the guidance we've published in the explanatory notes, I mean, the operation of the relevant clauses is a matter of public record. I think just in general what we have tried to do with shared owners is to make them a permitted lease within common hold. It's actually one of the key ways that we've updated the common hold legal framework to account for shared owners in this respect. When it comes to what shared owners would experience in a common hold setting, it's not dissimilar in a sense from non-contributing leaseholders, as we discussed, in terms of the rights and obligations that would pertain to shared owners. But you're, I think, Chair, driving at a different issue, or I'm not clear really what the question I'm being asked is.
Shared owners will continue to be leaseholders. That's correct.
And they become permitted leases within common hold?
Yeah.
Through the provisions in the bill?
What assurances can you give shared owners that this legislation as it stands will not present any new challenges for them going forward?
I mean,
obviously
go on. The shared owner provider will continue to be involved in decision making in the first 10 years on big repairs or anything that affects liabilities, but the rest of the decisions can be delegated by the provider to the shared owner. So the shared owner will have much more say in a lot of the decisions that happen within the Commonhold block than they do currently. So that will be an improvement on the current position. But some decisions will have to be retained by the provider in terms of the first 10 years of repairs and any kind of major liabilities.
And the provider can choose to confer Commonhold membership rights on the shared owner. So that won't be automatic, but again, that's in line with the Leasehold Law Commission's recommendations in that respect.
Andrew?
Yeah, I just briefly, I think, will you be able to, when you eventually table this bill at first reading, do you think you'll be able to set out a draft of what that secondary legislation will look like, so that it's going to be clear to the social housing sector and to current shared owners what precisely you mean by specified purposes, so everybody knows up front while the legislation is going through Parliament what the registered provider will have a vote on and what the shared owner will have a vote on. Do you think you'll be able to provide that level of clarity at first reading, or certainly by second reading?
As it stands, the draft bill doesn't set out what that purpose would be.
No, and like any piece of legislation, there's lots of secondary legislation that's required to enact it. I can't sit here and give you a commitment that we will publish the draft SI on the day we publish the bill, the substantive bill. No.
Okay. So those concerns from shared owners will still continue then until we have...
As with every aspect of the bill, Chair, the more clarity and the quicker we can provide clarity, the better we will of course do so. But I can't sit here with all of the various moving parts that entails to say that we will definitely have a substantive draft SI at the point we lay the substantive bill.
I mean, I think it is worth saying in the development of secondary legislation, as in the draft bill, we will work with a number of stakeholders so that we do kind of work through those issues. So I just wanted to give that assurance.
And I think that the bill and the accompanying materials do set out the principles on shared ownership relatively clearly, which is that we want shared owners to be sort of full participating members of a Commonhold association, and that is obviously one of the key reasons we've made the changes we have in the law. And there are some very specific scenarios which Caroline alluded to where there will be a split between providers and shared owners, but the underlying principle is that they will be full participating members.
Yeah, no, I fully appreciate that, and I think shared owners do as well, but we just want to reiterate the concerns that they've raised in terms of you could have a situation where shared owners won't have a vote on matters which are going to impact them, you know, mentally, physically, financially within that 10-year period. So we just want, and I'm sure this is something that you are taking into consideration.
Absolutely, and that will obviously guide the preparation of the relevant SI when it comes forward.
Thank you. Sarah.
Thank you. And apologies, Chair, I should have said at the start that I am a leaseholder and I should put that on the record. Coming back a little bit to my previous question, I just wanted to understand a little more for those watching how the government will seek to promote the awareness of Commonhold and ensure that leaseholders have access to the advice that they need on the conversion process.
So, I mean, I think I said this briefly, but in the development of the bill, we've worked with everybody that has a say involved in this. I mean, in terms of preparing future common holders, then we'll work very closely with developers, because obviously that's kind of hugely important in terms of people's decision to buy a common hold property. We'll work with conveyancers, we'll work with lenders. And then in terms of the own government bodies, obviously we'll be making sure that the land registry is well equipped and set up to take on this change, and lease is as well to provide advice to existing leaseholders and future common holders.
It's probably also worth saying that as the bill progresses, lease as a government supported service will obviously provide regular updates to consumers on what it means for them going forward.
I do, absolutely recognise the huge effort that has gone into engaging the sector as widely as possible. The truth is that for, again, the sort of man or woman who is a leaseholder currently, they quite naturally haven't been able to be as close to it. And it is complex, not that they don't have the capability and people don't want this opportunity to take control of their own properties. But what we heard from lawyers was basically you just have to pay more. When we tried to challenge some of the lawyers that we had in front of the committee around acts and some of the sort of failures that have been reported, specifically around conveyancing, the response was we have to pay more, which clearly probably isn't enough for people. So just to push a little bit further, really, especially when we had the chair of the Leasehold Advisory Service themselves saying they wouldn't be converting on day one because of, I guess, there's an element of risk to being in some of those early conversions, and recognising the complexity of it.
I think that was said in a personal capacity, wasn't it, rather than as the chair of lease?
Yeah, okay, I'll take that.
Should have
yeah,
been,
take
otherwise
that.
that
Take
would
that.
be blurring the lines between
I'll take
roles.
on that. And if we were to refer to the record, he said specifically in his role within
his block.
his own block.
Yeah. So speaking in a personal capacity.
But I think it highlights the need for equipping, supporting, advising people on this. So would you agree that it could be risky for those first blocks to convert for those leaseholders?
I think
risk is the word.
Every block is obviously very different, and every leaseholder within those blocks are very different in terms of their appetite for moving to common hold. So some people might be comfortable with their current arrangement, some really won't. So I do think it just depends, but I think it's the government's role to prepare the sector for change, to provide the advice and guidance through lease, through the land registry and any other government body, and it's now incumbent on us to prepare the sector for that change, and we will do that with a robust implementation plan. We'll also work with the sector. Like, government cannot do all this on their own. We will be really reliant on lenders and conveyancers to guide potential common holders in the future. So we're absolutely, completely aware that this is a big cultural change. The law is one thing, and legal change is hugely important, but it's not the end of the story, and actually driving that cultural change is going to be hugely important.
And to the extent that it's worth me saying, just sat as the Minister, to the extent that we can direct lease, obviously helping consumers get ready for common hold is a huge part of what lease needs to do over the coming years. And I just to say, Chair, that I will be formalising that direction, if you like, in my 2026-27 Chair's letter to the organisation, because that is a huge part, amongst other things, that it needs to do and do well.
The only thing I would just add to that very briefly is, whilst I don't want to go so far as to say conversion to common hold is sort of completely straightforward, it is not designed to be a costly or overly complex process. It's primarily about registration of the relevant products with the land registry. Obviously, it does depend on prior enfranchisement, which comes with great costs, as you know. But the process of converting to common hold and the work we're doing with HMLR in particular is going to be designed to make that as easy as possible.
And do you want to say anything further on what specifically you're doing with conveyancers and solicitors to prepare them for this change beyond what's already been spoken about at all? Anything further that you'll be...
I think I suppose I'd make a general point that the information needs of buyers under common hold won't be that dissimilar to the needs of buyers in resident leasehold blocks. It's obviously already a feature of the housing market. And we expect the process in the end to be simpler and quicker than that for leasehold flats once it's bedded in. There will obviously be a transition point. But in terms of engagement, is there anything we can say on engagement with conveyancers or the conveyancing industry?
We are engaging and have done as part of the policy development of the bill, and will continue to do so. And we know industry groups, including conveyancers and others, will be developing their own guidance, and will be supporting that to make sure it's complementary. I mean, as you say, it is a whole system approach in terms of sort of determining its success.
I think some of the concerns that we've heard as well was around when we challenged land registry. I think just their slowness in terms of recognising moving into the digital age. So I hope those discussions are happening, because I think that session was an eye-opener for us in terms of, is the land registry ready for these changes coming forward? I think, again, if Mr. Cockin he would ask in terms of the conveyancing process for leaseholders, that pack where essentially some of the costs and fees are quite blurred and hidden, unless you're very detailed in looking through what you are going to be liable for as a leaseholder. So in essence, knowing that the government is working with the sector to prepare people in terms of not just being a leaseholder but being responsible for day-to-day management and financing of your block or flat is really welcome, because what we don't want are many people, in essence, probably saying that they were missold and not fully aware of what they are taking on as common hold.
Yeah, there's that angle, and then there is definitely, again, back to the managing agent piece, having a managing agent regulatory framework that ensures that where managing agents are still managing those blocks, because they will be in lots of instances that is being done effectively. Chair, I think it's probably, you've had ongoing engagement with the department over this bill, but there's a number of technical questions about the consumer element of common hold, which we're obviously more than willing to provide further information on.
That would be helpful.
Yeah.
Thank you, Minister. Sean.
Minister, on 27 January the government launched a consultation on banning leasehold for new flats. That's obviously looking at the sort of scope and the timings for that, and I know that closes on the 24th of April. Without sort of prejudicing that, but based on what you've heard from industry and over the last couple of weeks, as well as your own sort of personal thoughts, so to speak, do you have what sort of timeline we'll be looking at, or what would your preferred timeline for that be? Because obviously that's not in the bill.
I think we need to analyse the feedback to the consultation. Some of what we are trying to get at and elicit views on through that is what is the potential risk of disruption, what does that look like in specific terms, what exemptions are required. Obviously, I suppose I go back to the general point, we want these things in place as quickly as possible. There's a corresponding element here, which is we're not going to switch on the leasehold house ban that's in the 24 Act until this can be switched on, so they're both aligned. So it's, for those in houses as well, there's a particular issue on it. But on timelines, I don't think there's anything more we can say at this stage.
No, just beyond saying that obviously we want the reformed common hold framework to be operational before the flat ban comes into force. We want it to be sort of set up and ready to deliver, but as you say, Minister, sort of decisions on transition will be informed by that.
Is the intention that it's within this Parliament?
I don't think in terms of actually switching on the ban that decision has yet been made.
Potentially not then.
We have to weigh, as I've said, and it's what the consultation was designed to elicit. Is there a significant impact on housing supply, for example, that would mean that the transition has to look a certain way rather than another? So, but there is a potential that ban on new leasehold flats could not be in operation before the next part. I don't really, I suppose, Mr. Woodcock, want to kind of give the public the impression that that's our intention. It's not. No, sure. We just haven't made a decision.
You touched on supply. Is there a view that it could impact on that 1.5 million homes target and supply?
One of the things, again, we want to get at is acknowledging, which I think the committee would acknowledge, that developers, other parts of the market, will need time to familiarise themselves with the common hold model and what that means. This is quite a big transition. That's why we are trying to seek those views on transitional arrangements, the timing of the ban, so that we can have as smooth as possible journey from one to the other, and that will inform our decision. But I am sure, what is there, I suppose, we can say without giving away the consultation responses? I'm sure that the impact on supply will be a feature of lots of the representations we've received as part of the consultation.
And I suppose, I know it's very limited, but common hold does already exist. It's not obviously widespread at any. So in a sense, the sort of the product is sold almost tenure neutral, almost. Yeah. We need to make sure people are familiar with it and understand it, but I don't think tenure in and of itself...
But we did hear evidence from Philip Rainey case in the remarks that unless there is a sunset clause, it is unlikely you'll get a high degree of take-up of common hold. So I suppose that's the sort of query, is that it's pushed back and back. The intention of the bill is not going to be matched by the outcome.
What do you mean in terms of take-up of...
this was referring to the previous Act, the 2002 Act, and the fact that there was no sunset clause impacted on take-up. But
I think that's why the bill includes, obviously, the statutory provisions on sale of new flats. It's precisely to address that. The failures of the 2002 model to take off properly have informed the decision to include this.
That's why the timeline question is so important. And
when it comes in, it's important. Yeah, I absolutely acknowledge that. I think it's important we get a smooth transition. In the very high-level conversations that I have had with developers, and we've had roundtables on this issue, none of them have said, please don't do this. It will, you know, you'll be taking us into a world where we can't operate. The concerns have been around, you know, what's the timeline? What are the transitional? How do we all ensure that the process and the switchover is as smooth as possible? But I think doing it in an ill-planned and hasty way could have an impact on supply. I mean, it's certainly one of the things we're alive to and what we want to further explore. Yeah. Partly why we launched the consultation alongside. Yeah.
Thank you.
Thank you, Lee.
Yeah, thank you. So, I think you've covered parts of this throughout answering lots of different questions, to be honest with you, but it's a summation question. So through this draft bill and LAFRA, what changes do you expect to deliver for leaseholders by the end of the Parliament? As I said, you've touched on quite a few of them throughout your questions, but a chance for you maybe to sum it up at the end.
What's the easiest way to sum that up? That is a big question. Essentially, we want to... Let me approach it this way. I think in terms of, and this goes back to those opening remarks, what do we mean by end? We will have, by putting in place the legislation, take Mr. Woolcock's point about precisely when you switch on some of the provisions, but once this legislation is in place, common hold will be the default tenure going forward.
So just minutes. So what do you expect to deliver for leaseholders by the end of this Parliament? Yeah, so I think that question includes what would have been switched on as well by the end of the Parliament.
Well,
so it's in your gift, not a new minister.
It's actually in your gift because you can help me get the bill through.
But try.
We will if you make the changes we suggest.
And I don't want to sound obtuse, but I can't tell you when this bill receives royal assent, the substantive bill. I can't tell you when each piece of secondary legislation is enacted. So the timelines are variable. I gave in my oral statement when introducing the draft bill an estimate of 2028 for some of the provisions like ground rent. If we can pull that forward, I would love that. I would love to switch these things on as quickly as possible. In general terms, what we expect to be in place, what we expect leaseholders to benefit from by the end of the Parliament is a range of greater rights and protections, the abolition of forfeiture, the ground rent cap, all of the benefits that, as limited as it was, the 2024 Act provides for. That's service charge standardisation and transparency. So we will make the existing leasehold system work more effectively. If people don't want to convert, they can remain under leasehold ownership. They can enfranchise. As again, it comes back to Ms Smith's point, we want a range of options open. But through the measures in this bill and further legislation, we will have ended the system in a sense. And then to the extent leasehold is not abolished overnight and will be with us for some time to come, it will wither on the vine. And I would think the incentives will be in place to ensure that in lots of cases people are converting and we're seeing a more wholesale switch over to common hold. What we've tried to do through the bill, as Rachel said, is to avoid all of the mistakes that were made with the previous legislation on common hold, where there was a voluntary element to it. The legal framework did not work for a variety of reasons, and we haven't seen, obviously, to say we haven't seen wide take-up is an understatement. There are 18 common holds in existence. So we've tried to design the legislation to ensure that that's the big thrust of what goes forward.
Thank you, Minister. I just wanted to come back. I digressed a bit and abusing my chair's position on obviously the announcements around new towns. You kindly came to our one-off session earlier in the year, and I asked about the strategic environmental assessment, and you'll remember you outlined that no decisions on sites will be taken until the SEA reports are concluded. Can you give us an update on when we will see the SEA reports, and will they be accompanied by any final decisions from your department in the spring?
So we published consultation on the draft programme and the SEA yesterday. Are you aware of that?
No,
you weren't aware.
My apologies, I would have missed
it. We published it yesterday. So what we're now asking for views on, with a view to making decisions on final sites and the scope of the programme in the summer, we're asking for views in a brief consultation yesterday on the programme itself, and 7 proposed sites to take forward out of the 12 recommended to us by the New Towns Task Force. But we have to consider through that process, those 7 sites, any reasonable alternatives to them that might exist from a wider list and from those 5 that we're not taking forward.
And in terms of those, are there specific further sites that you'll be looking at on the SAAs, or is it just within the scope of the
We're proposing
12
to
recommended
take forward
report?
7 sites from the New Towns 12. As part of the consultation process that we launched yesterday and the SEA, we're obliged to consider reasonable alternatives. In terms of looking at those reasonable alternatives, I think I detailed from memory this to the committee previously. We looked at the sites that the New Towns Task Force recommended, the wider list of sites in their call for evidence, other sites that Homes England were already aware of, a huge range of sites, and whether they met our objectives and whether they should be considered. And as I say, once this process is finalised...
And I hear you on that, Minister, but would you then, in a sense, say that, in essence, undermines the independent process that you asked the task force to carry out in terms of recommending a series of sites, if you're now saying you're going to be looking at and considering alternative sites?
I think the simple answer to that, Chair, is it's just a part of the SEA and programme consultation process that we have to consider under that relevant legislation, reasonable alternatives. I don't think it undermines the independence of the New Towns Task Force. We never said to the independent New Towns Task Force when we established it, we will, under all circumstances, take forward whatever you propose. We said recommend sites to us. We've done our own assessment of those 12 sites, and we have taken forward the 7 that we think most closely adhere to our objectives, give us the most benefits in terms of tackling the housing crisis, addressing housing need, and unleashing economic growth. If you look at the consultation we published yesterday, we set out in quite considerable detail why we've chosen the 7 sites that we have and why we've not taken forward the others. Although I should say, partly on the basis of some of the commentary that I saw yesterday, the fact that we have proposed not to take forward 5 of the sites that the New Towns Task Force proposed does not mean those sites will not be built out. I fully expect them to be taken forward through other routes. And in the case of Plymouth in particular, we've highlighted in the report that needs special treatment and bespoke support, including financial support from government, because of the potentials down there and, frankly, the national security requirement of ensuring that housing is not a constraint on having the skilled workforce in place we need down there.
Right, thank you for that. Thank you for coming before the committee and to the 2 officials. I think we are still hopeful that it is your intention as soon as possible to introduce the bill in the next parliamentary session. Just to remind people that our online survey is still open. It closes at the end of this month on the 31st of March. To date, we have received over 5,000 responses, and there is a lot of appetite, a lot of interest in this very technical and large bill. But essentially, we want to make sure that this bill is right and it brings to an end the feudal leasehold system. Thank you for appearing before the committee this morning. Order.